My name is Leonard Lang. I'm president of Upper Room Consulting. I consult with recyclers, processors, haulers all over the state. I have been in this program since the beginning, and I sincerely thank you for this opportunity. I believe this is the first oversight meeting that has been held since Byron Shear left the Assembly some time ago. Just to give you a little background, in 1987, my employer assigned me the job of the bottle bill. And within about 6 years, we were the largest beverage container in the West, number 2 in the United States, certainly the biggest in the state. I trained and assisted not only our own businesses, but other recyclers. I have run recycling centers, processors, MRFs, operated curbside operations. I'm familiar with all aspects of this operation. In 2007, I recognized that the industry wasn't staying up on the regulatory problems that they were facing, and especially immigrants. So I went into business to assist them. I have defended more recyclers in this state than anyone else. I've probably read over 20,000 pages of department accusations. I am intimate with the statute and the regulations. I have successfully petitioned OAL to rule underground regulation on some of the actions of the department. Now, in 1986, this program started, and it was basically an experiment. And we all got involved, and it was the blind leading the blind. It started in 1987, and by around 1991, Charles Calderon had introduced a bill that would have imposed standards on the operations of the program. What we saw was that the legislature gave the responsibility to the division to audit and to investigate, but we didn't ensure there was competence, and that's been the problem with fraud. In 2002, we saw a first loan come out of the program, which affected its solvency. 2003, AB 3056, I call it the Christmas tree. It gave away lots of money and started the drain on the fund. 2008, 2009, we saw the financial disaster. We saw the fund approach insolvency. Proportional reductions were imposed. 2010, important year. The legislature requested an audit. The first audit report by the State Bureau of Audits showed ineffective management and statistical incompetence. Also that same year, LAO said budget bills were not a place for beverage container legislation. 2011, the department issued a notice about out-of-state containers. I argued with them for about 2 years. Finally, the former head of the Office of Administrative Law wrote a petition, and the department was forced to admit that they had imposed underground regulation on the recycling industry. In 2012, we got a new deputy director, and he came out of the medical section of the government. He came with a term called pay and chase, and that led to an increase in underground abuse. Convenience zone pricing abuse started around 2012. I have that on a YouTube video. It's available for anybody to see. That abuse was a magnet for out-of-state material. In 2013, OAL overturned that notice. Also in 2013, we saw SB 96, a budget bill. It extended the certification times for recyclers, making it more difficult, more expensive. It established load limits. It eliminated commingle. That was detrimental to the glass industry and the hospitality industry because that gave them good quality furnish. Then they imposed training classes on the industry, and they forced us to use a computer system called Doris. Both added additional costs. Doris is now being used to profile applicants into the system. 2014, we saw another budget bill, SB 861. it increased the statute of limitations 250%. Both SB 96 and SB 861, language came from the department. Industry was not consulted. In 2014, we also have the second audit, which came out poorly for the department. In 2016, we had another budget bill proposed, and we identified fraud going through the curbside systems. DOR has had major staff increases during 2016, and their legal costs are rising because I and another attorney are successful in challenging their accusations. 2017, we're looking at insolvency and modernization. Right now, I say we have a house built on sand. My recommendation, request another audit. Audit, enforcement, certification, and DORIS. The two audits already exposed quite a bit, but this hasn't been dealt with. You will find the answers that you need to shore up this system. And if it wasn't for the insolvency, we wouldn't have started these meetings to begin with. Now, my recommendations, you need standards of competency for audits and investigations. The Calderon bill would have established audit standards and also would have put Department of Justice in charge of all investigations. You can't just hire a college graduate and stick them in investigations. They don't know what they're doing. Right now, any auditor with a laptop can go in and make changes to the payments to recyclers, which completely circumvents due process and the right to appeal. I also think that there's been a problem. There's the Dimely-Alatori Act, which requires state agencies to create information in languages. And majority of the recyclers in this program are Latino. They have never published the act or the regulations in Spanish, which I think is what the Dimely-Alatori Act requires. The statute has fraud indicators built into it. My recommendation is you take those fraud indicators out and put them into regulation because the department misinterprets them. Right now, the original statute has an exemption to adopt permanent regulations. The department can adopt emergency regulations and they last forever. There was never a sunset put on that provision. It needs a sunset. We've adopted emergency regulations with SB 96, and I've petitioned that they adopt them on a permanent basis. They have not. We're still running on emergency regulations. That denies the industry their right to participate in rulemaking. I recommend that you eliminate the informal hearing. It's cheap injustice. It's not due process. And you need to adopt standards and formal standards for the formal hearing when a department is going to rewrite a decision. I recommend you repeal SB 96, 861. Recyclers were guaranteed that they could make money in this program, and if proportional reductions are imposed, more are going to die. If you take proportional reductions out of Section 14581 and put it someplace else, it won't be hurt. Recyclers will not be hurt. Now, there's a question of whether or not redemption is 5 cents and 10 cents or 4 cents and 8 cents. I recommend that the committee look in what was the legislative intent and what should the redemption be at this time. 2 years ago, the department entered into a memorandum of understanding with the U.S. Department of Labor. There is no authority for a state agency to go into contract with a federal agency. The result has been that the federal agency is coming in and interrogating recyclers on issues that have nothing to do with Department of Labor. They're asking questions on CalRecycle's behalf. Now, I go to Phoenix frequently. The current street price over there is $1 for cans, 50 cents for plastic. This is a good indicator, good benchmark to see how well your system is working. Now, the department has conflicting goals. In one sense, we're trying to increase recycling, especially with the 75% goal. And on the other hand, the Cal Recycle is trying to reduce recycling. I have clients who have applied for certification at convenience zones and have been denied. Probably the most egregious place was in Visalia. Less than half the town is covered. I had a recycler apply for 2 locations. He's been in business 8 years. He was denied. You need to bring fraud under control. I don't think it's that hard. Recycling is a physical, tangible, logistical business, and you can follow this stuff. I've identified 3 locations in Phoenix, plus a yard which converts the material and ships it to Los Angeles. I've taken a picture of a 53-footer backed into that location. I've provided address, GPS coordinates to the department and to DOJ. I'm here to protect recyclers and the public.
I appreciate that.